Everybody, thank you for your time. Thank you for attending. We're going to talk about preserving your intellectual property at a time of disaster. My name is Dave Stevens. I'm an intellectual property attorney. I also help set up and found startups, and I work with middle-sized companies, Fortune 10 companies, and these concepts apply to all types of companies, all sizes, certainly at a time of disaster, because all of these tools and all of certainly services and other types of things you can do with the U.S. Patent Office, Trademark Office, Copyright Office, it's open to anyone. The focus of this talk is really about, first we're going to learn what is intellectual property, what are the different types, and how do you preserve your intellectual property at a time of disaster, and really how do you really strategize so that no matter when you are cutting or growing your intellectual property portfolio, there are concepts to be aware of, and as long as you stick to those, you can optimize the value of your intellectual property so you don't cut out things that are valuable. So it's really about IP asset management in a stressed market. And frankly, I think that if you apply these concepts even in good markets, although you're looking for more opportunities, you might invest more, they're good concepts to always be aware of and to revisit several times in a year, even monthly, if not quarterly, so that you know that you're optimizing your assets. And to do this, you need to be a sophisticated consumer of IP services. And that is really understanding your intellectual property. So you're going to be a strategic expert in IP development, and I mean you're going to be whatever level that you attain to be, but working closely with your counsel and trusted counsel, you can learn a lot about intellectual property, so you can share in the decision and not just rely on somebody else, whether it's someone outside or someone on your staff. It's really about having a holistic approach to intellectual property, about being collaborative, and having all the stakeholders have a say-so in intellectual property so that you can really optimize this asset or portfolio of assets, right? So first of all, I'm going to go through the basics of intellectual property, preserving and investing in IP during a disaster or any time, and generally IP legal services. And this kind of thing, it's the first time people think of, certainly with a small company, should you save money and do it yourself? And there's some things you can do and some things you should probably get help with. And of course, as I'm a TiE charter member, I give special services to TiE members who have startups, or even if they're in big companies. I'm always available for general advice and guidance. So don't ever be afraid to call. I won't always have the meter on. So here's the good news. The U.S. Patent Office, the Trademark Office, the Copyright Office, these offices are all open. And even when they have their ups and downs, it's an online system now. We do all of our filings online. Often we need some kind of special guidance, or we have to, take care of certain things by calling the office and talking to people. But it's rare, and most what you need to accomplish, you can accomplish online. So it's never going to be down. You can still invest in your IP, and it's also an opportune time to create IP assets. And there's a lot of reasons for this, and we'll get into these. So the question you want to ask yourself first, I normally do a poll, but I'm not sure this is really set up for this, is how does your company view intellectual property? Now, with startups, you often will have a product, some technology, something you're developing, and you need to get some patent assets you feel would protect this product, would protect you from getting it stolen, copied, or if someone just invents it, and files patents before you do. Is it a legal cost? Or you might even ask, why do we even need IP? And probably you should ask the third question first if you're not really sure. I can give you a lot of reasons why people invest in IP. That is, they pay to register different intellectual property. But you really have to educate yourself, learn more, ask lots of questions, especially with me. Ask questions of me here and even offline, so that you really understand what you're doing with your IP. And the more you understand what it is you're buying, just like any product, the better purchases you're going to make, the better investments you're going to make, the better decisions you're going to make about growing or shrinking your portfolio whenever those times come. Now, this gets into the reason why you file for IP. Why do you have intellectual property? So the U.S. Commerce Department, they surveyed and determined that intellectual property intensive industries support at least 45 million jobs and contribute more than $6.6 trillion. That's 38.2% of the U.S. GDP. Now, it seems big. It seems out of proportion. But the fact of the matter is, it's one of these things that we take care of. We're in the rear with the gear. You make money off of selling products and maybe licensing technology, but intellectual property, new ideas, concepts that are created by individuals are the most valuable assets in the world. And with a modest investment, you can protect these things, register these things, so your company owns them. What is intellectual property? So this is just a survey list, and I'm going to stop after this slide and ask for any questions. In fact, you can stop me at any point, and Nihar, please interrupt me if someone has any questions to come up, because I want to talk about what you want to talk about, and I don't want to move forward if there's something that I haven't been perfectly clear about.
Okay, I'll do that.
Great. So let me go through the slide and then I'll stop for questions, and feel free to, reach back however far you want to and ask questions. So patents, trademarks, copyrights, and trade secrets. So these are the basics of intellectual property assets. Now we'll talk about registering them, protecting them. You have rights, however, even if you never register these. You don't file patents, you have trade secrets. Trademarks are owned by use. Copyrights there's an inherent ownership if you are original creator, right? So let's go through each of these briefly. Patents, when you file for a patent and for an application and you get a patent issued, the issued patent gives you the power of excluding others from the unique function that you have created. Now, the way these things are described in patents can be, electronics, they can be components, they can be mechanical. It really gets down to the function of these operations and the way that they operate that's unique to others. Now, if you have something, basically to get a patent, you need two things, right? It needs to be new and it needs to be useful. It also needs to be non-obvious. That is, if there is some obvious change, some obvious operation that you've put into a product, you can't get patents on those, and you can't get patents on abstract ideas. But at a high level, if you're considering patents and you haven't filed patents yet, you should compile a list of things that are new and useful and do a triage with a patent attorney and talk about what may be patentable. Throw out a big net, go back in time if you've been developing these things, look at really what you have done to solve problems and what you've developed that is not off the shelf. Because solutions to problems are inventions. It's that simple. And usually it starts with the problem. Now, you might have difficulty coming with a list of inventions, things that you've done that are new and useful. Often what I find is really effective is you talk to the inventors, the technical people who build these things, engineers, anybody can be an inventor, but you talk to anyone who has laid out the problem and has taken lengths to solve this problem. Those solutions they've come up with, however they're embodied in your product, can be patented. And you want to focus on those, certainly with the patent attorney, maybe do some searching with the patent attorney to see if it's novel, see if it's been done before, see if it's been patented before. And from that, you can decide what you want to patent. Now, you can combine those, we call them omnibus applications, multiple inventions in one patent application. They're bigger, they can be kind of clumsy, but the patent examiners like them, and they're very powerful because at any time while an application is pending, you can file a new set of claims on a different invention as long as it's embodied in that application. and you are awarded the original filing date. It's called a continuation practice. Now, you know, these are very intimidating patents. They're very good, especially for startups, and they're good for companies that may enforce or license them. Probably the poster child for these is the iPhone patent. It's the best omnibus application you're ever going to see. I mean, it was written by multiple people, but it was probably 1,500 pages when they filed it, and it covers everything soup to nuts: software, hardware, touchscreen, firmware, everything, right? And at any time during its pending, you could spawn off a new set of claims. And if you look up, you know, Apple's history, they've spawned off many claims on these applications. So they're great for you, and even for a company that just has a few inventions, a new product, startup company, because it allows you to get other combinations, permutations of different inventions in one: system claims, device claims, and you can pick from different parts of your product and claim them in single claim filings. And each filing that you make of claims, that is a separate patent application. Even if it is the same specification, different claims, they issue as different patents. And for due diligence, raising money and things like that, these are considered separate patent filings. And when they issue, they are separate patents. It doesn't matter if you separate them out or if you put them together in an omnibus application. They're examined separately and they are issued as patents separately. Now, trademarks is for protecting your brand. Now, you gain trademark rights by using your trademarks. You label your sales documents, different things on your product, your actual product itself. In software, it is, you know, the first splash page, or, you know, the bundle that comes with it, or the website where you order these things. Those are your trademarks. By their use, just by using them without registering them, you obtain trademark rights. When you register the trademarks, you submit your, whether it's your logo or your name or both. It could be the house mark, it could be a product name. Those, once they are registered, they're examined by trademark examiners. It's determined whether or not there would be any confusion between this mark you're proposing and other marks that have already been filed. Once you have them, violations or use of your trademark by someone who's not authorized, or a company that's not authorized, gives you statutory rights. You can get, you know, thousands of dollars per infringement. So if some website is using your trademark and selling your product secondhand, or just using your, you know, copying your product, just using your trademark, you can get violations, damages per violation. They can add up very quickly. So that's the benefit of registering a trademark. Copyright, similarly, you have, when you have an original work that isn't derived from someone else's work, whether it's software code or a book or a movie or any kind of expression of any kind, then you have rights, common law rights, as they call them, just like common law trademark rights for use of the trademark, statutory rights for filing and registration of a trademark. You have common law rights in the creation of this copyright, this work, and you have statutory copyrights when you register the copyrights. And each of those roughly are in order of cost. Patents are relatively expensive because it takes a lot of lawyer time to put it together, fees. Trademarks take less than patents. Copyrights are a simple registration. It's a fill in the blank sheet, and you get help from an attorney doing it, but you can apply for copyrights and you get expanded rights. Again, you can get violations per copy. Trade secrets are unique here. And trade secrets are something you don't register with the patent office or the trades. There's no trade secret office, right? What you have to do is to take steps to protect your trade secret. And if anyone steals them from inside or outside, you have rights to go after them. They can even be criminal penalties. And you just need to prove that you have this trade secret. So for trade secrets, you must keep some kind of recording that's dated, whether it's a document inside of a physical file, electronic file. You just need to have proof that you had possession of this trade secret. You kept it secret. You took steps to keep it secret. You locked your doors. You had passwords to get into certain servers. the world didn't have easy access to your trade secrets, right? You had employees sign documents that they, will keep them confidential. If someone comes in and you share them with them, vendors, customers, and others, they must sign confidentiality agreements or have some kind of click through in your systems so that they agree to protect your trade secrets. There's a company who had their trade secrets stolen from someone on the inside, and it was a pretty big deal. And they sued for trade secret misappropriation, theft. They were required to show certainly that they had the trade secret, that this person had access, and that they took it without authorization. Where they lost the case is where they needed to show that they had possession of this trade secret. They didn't have any kind of recording. There was talk about it. It was discussed in meetings. It was part of their product roadmap, but no one had any dated recordation of this. Even an email sent somewhere, hey, here's our trade secret. Nothing that could show that. They ultimately lost that case. Although they took steps to protect their trade secrets, they did not take the important step of recording it so that it could be proven later that you had possession of it on a particular date. Okay, so that's my primer for what is intellectual property. I'll take a break here and see if anybody has any questions on this or anything I talked about prior to this. You could type in the question in the discussion. Nihar, you'll get those, right?
Yes.
Because I don't see that in front of me.
You guys can either put them in the chat or in the Q&A button, and we'll get those sent over today.
Right. Right. If you have anything now, it's great. Otherwise, I'm going to move on. But feel free to interrupt me. And Nihar, please interrupt me if any questions come in. So the different alternatives, let's just talk about patents for now. And I'll get back to any trade secret, trademark, copyright questions if there are any. Patents, really the purpose of this discussion was really to get into intellectual property and specifically to talk about what you can do to protect your technology and your patents during stressful times when you're trying to save money, you're trying to cut back, right? But you still want to protect. Now, any steps you take to protect your intellectual property, you're investing in your intellectual property. And you can file provisional applications. They're relatively inexpensive. You can even file them yourself. In fact, you can do any of these things yourself. But they're a bit complicated, and there are certain things that you really should know about before you file these things, because if there's any mistake, or if it's not detailed enough, or there's something that's imperfect about it, that imperfection is not going to go away. And attorneys, I mean, there's a quick checklist of things that you can do. It's worth spending time with a patent attorney, someone who's registered, to go through this so that you understand and you're confident that whatever protection that you're investing in, any steps that you're taking, are the proper ones. They're thorough enough so that at least you understand what protection you have. Often companies will just do a quick filing, maybe a marketing document that talks high level about their product, but it doesn't really preserve any rights because you have to put put details in. You wait over time and you don't realize until you're with an attorney and you're filing a non-provisional application that it's not adequate and it doesn't preserve your filing date. When you file a provisional application, you are awarded a filing date. You get a serial number. Within 12 months, if you file a non-provisional application, and the non-provisional application is more detailed, there's more of a story, there's a background, there's a specification, there are formal drawings with numbers, there are claims, properly paid fees, right? If you do it right, and if your provisional application is detailed enough, when the examiner searches the claims of your non-provisional application, hopefully they will use the date of your provisional application. The times when they do not use your provisional patent application date is when it doesn't support the claims you're after. So if you're claiming extra details that you came up with later or that you just happen to file with your non-provisional application, if they don't exist in your provisional application, then you will not get that early filing date. And they will start searching from the date of your non-provisional filing, which can be up to 12 months after that. So you look at the different, values, provisional applications, well, the costs anyway, provisional applications are relatively inexpensive. In fact, for our firm, for TiE members, I'm a charter member, so I give special rates for TiE members and startups. It's $640 flat fee. And that's assuming that you do all the write-up, I'll do a review. If it needs work, then we work out some other price. But typically it's not that expensive, and it's a good way to preserve 12 months of any of your inventions. Non-provisional applications are a bit more expensive. They can cost anywhere from $8,000 to $12,000, depending on how complicated they are. Omnibus applications with many inventions can be more, but generally when you file an omnibus application, it's much less expensive than filing them separately, because we base our flat rates, our ceiling rates on time. Of course, the potential future value is very high. Doing nothing could ultimately be a substantial loss. I think I saw some questions coming in, am I right?
Yes. One question was, is an NDA enough to be signed, or does an actual contract need to be signed?
Very good question. So the purpose of filing a patent application, whether it's provisional or non-provisional, is to secure your rights domestically in the United States and also in foreign countries. Now, if you make, use, or sell a product that embodies your invention, or if you disclose it to a potential customer or to anyone who's not under a non-disclosure agreement, then at the point you've done any of those things, you have 12 months to file in the United States. There's a grace period. In foreign countries, the moment you do those things and you don't have a patent application filed, you lose those rights. So I'm going to repeat that. If you do not file a patent application and you talk to people, potential customers, potential employees, potential investors, anybody, you sell a product, you put out some kind of a beta version of what you're making, whether it's a product or an actual physical product, or you open your website to a certain function. If your inventions are part of this thing that you've given out or you've sold, you've lost all of your foreign rights in any of those inventions. If you have a non-disclosure agreement first, you're safe. You're safe. So if you haven't filed a patent application and you've done any of these things, you file a non-provisional, or you have a non-disclosure agreement. As long as you haven't made, used, or sold these things, if you disclose these things under non-disclosure agreement, you preserve your rights. As soon as you do those things, you need to file a provisional patent application or a non-provisional to make sure that you secure them. So if your product is in beta, you're not charging for it, you're letting people use it, we're talking about a small number of people, they sign a non-disclosure agreement. It could be a click-through if it's a sample web page, if you're showing customers how things work. They sign a non-disclosure agreement, they use your product, they haven't bought it, so it hasn't been sold, and it hasn't been disclosed to someone who's not under NDA, you're safe. So you've preserved your foreign rights, and the clock for 12 months has not begun for the United States. Now, before you rely on this answer, whenever you're ready to do these things, talk to an attorney, because there's lots of nuances, and there may be some things that you do that might trigger one of these things, that trigger you to lose your foreign rights or to start that clock for 12 months for the United States. I had a client come to me who wanted to do a beta, and they have NDAs and all those things, but they charged a discount price, and they thought that was okay. It's not. If you take a penny or a fraction of a penny for use of any of your products by anybody not under non-disclosure agreement, you've lost all your foreign rights. And the moment you've done that once, any of those things once, you have 12 months to file in the United States. Are there any other questions around this? This is a very important one, because often this is where startups try to go off on their own. They get their NDAs, like, okay, we're safe. We're not going to spend money on a patent attorney to file these things. Let's see if our product has any, if it's sticky anywhere, if we can get any traction out there. You want to get the NDAs, but you want to file provisionals as soon as you can, so you have the freedom to do these things.
So there is a comment from Daniel Herman, who's a patent attorney from TiE, Germany. He's saying in Europe, you have to file first before you disclose anything to anyone. Keep that in mind that NDA may also be breached.
Mhm. Right, right. So the NDA, doing beta agreements, doing beta releases and everything, you're always better off filing non-provisional applications, something before you do any of those things. Any other questions at this point?
I think that's it for now.
Okay. All right. So you want to be a smart consumer of IP services, and it's all about strategy, right? So often, the times are tough, whether it's through disaster like you're facing now, or a company just needs to cut the budget for any reason. They'll say 50% across the top. We're cutting, right? You want to be in a position where you know what to cut, how to reduce. If you want to stop foreign filing or reduce foreign filing, reduce newer filings, or just cut back in any way, these are investments in your intellectual property. Once your portfolio gets more complicated and you have many other assets in different countries, you have other things pending in the patent office, you want to understand what you have. So when someone comes and says you have to cut, you're going to find the IP, you're going to choose very selectively which IP you're going to cut based on the company's needs and based on the value of the IP to the company, right? So in startups, the leadership needs to understand intellectual property to strategize. What are you investing in, right? Copyrights are relatively inexpensive. You can register these things, or you can cut back and wait and don't register them. Same with trademarks. The trademarks, however, if you don't register them, they're geographic in their force. So if you have limited use of your trademark in your business practice or in your commerce, then you're going to be limited geographically to where you have trademark rights. So if someone else comes in and starts using a trademark either in a different part of the United States or in another country, you could lose those rights because they used that trademark first. And if you didn't have any use at that time, then you don't have any common law rights. When you register your trademark with the U.S. Patent and Trademark Office, then you have geographic rights over anywhere in the United States and the U.S. territories. But if you want protection in Germany, as our caller had, or any other country, you need to file in those countries if you want that protection. Now you might think, well, if you're filing for trademarks, there's hundreds of countries, right? By 180 under the VCT. Well, you can, if you're careful and if you're strategic and you work with your attorneys and you figure out where your best use of it is, you can be selective in countries. You can file in Europe, you can file in individual countries to save cost. You could file in certain countries in Southeast Asia and other places, and you want to look generally where you have customers and where you may have competitors. And there's other uses for filing trademarks. So you want to figure out strategically, where are your trademarks valuable? Your house mark, your product marks, where are they most valuable? Where are you going to need that protection? Patents are much more broad spread because wherever your product is, but you can also focus on your competitors and your customers. And you could make, if you really had to cut back, you could have a reduced number of patent applications. Not all of the US applications you have, maybe separate important central value ones to file in foreign countries. Typical companies file, larger companies file maybe 10 to 15% of their patents in foreign countries. They're very expensive, there's translations, and the trademarks as well as patents are much more expensive when you start expanding to foreign jurisdictions. You have yearly filing fees often, maintenance fees. So when you start cutting back, it helps geometrically. And when you start filing in foreign countries, the cost can go up geometrically, right? You want to first have visibility of to assess your IP for your budget, so you can set the budget. If you're going to cut the budget, you want to be very careful and have everybody understood, or all the stakeholders understand what IP is valuable and what IP may be valuable but can be cut back based on the financial health of your company. In either case, the management has to drive a holistic approach to the IP culture. So, CFO, has their own objectives and needs and understandings of intellectual property. It's not just a cost. This is strategic. These are corporate assets, and they could have opinions regarding, which IP should be invested into, and if you're going to cut or if you're going to add, what direction it should take. CEO, of course, they're driving the ship. And if intellectual property is a driving force of the company, then that CEO needs to understand the intellectual property for his purposes and will have input to those decisions. Engineering, marketing, sales. Marketing and sales, they know what the company message is. They know what features are selling their product. They're usually the best sources of what intellectual property is most valuable. That's usually where the CEO turns to. What do we need to protect our product? Why are people buying our product? What's our differentiator? I worked with a company who had a very expensive product, and it cost tens of millions to sell, with millions of dollars in subscriptions going forward. Now, they had trouble going into these sales pitches, differentiating their product from their competition. And everybody seemed the same, and theirs ran better. They couldn't articulate from a technical perspective what was better about this, what was different than other companies. So we went through this long exercise of figuring out what is new for the patents. What is new, what is not obvious, what has been done that is by this company that's never been done before. And we were having this long discussion about what is the invention, what is new, what is useful. And this company, these people never went through this exercise. A couple months later, I spoke to the CEO. He said, aside from protecting this IP, the most valuable thing that came out of this exercise was they figured out what differentiated them. And when I looked at their website, I saw these patent terms, at least the functional patent terms we were using, were all over their marketing material. Now they were able to differentiate it. So if you're having trouble trying to figure out what's different, or if you're looking for new material, new differentiations for your product, the best people to talk to are the engineers, the inventors, the patent attorneys. And in the other direction, when you're trying to figure out what's new and novel, then the marketing people and the sales can really be helpful. And if you're trying to figure out what intellectual property is most valuable, they know what people are focusing on. They know what they need, and they know what the customers are asking for. So these are all great metrics to share together, all these stakeholders, to understand what intellectual property is valuable, what is worth investing in. And if you're going to cut, what do you not want to cut to preserve that differentiator so that you protect the intellectual property that gives you that differentiation from your competitors. And you have to manage with verifiable metrics. That's where you get them from. Everybody has a say-so. Everybody has a seat at the table. CEO makes the ultimate decision. Whoever's poised with managing the IP makes that decision. I was giving a talk to a group of CFOs, and we did a survey. Who manages your intellectual property? Who makes the decisions? 30% of this group, there were 85 of them at the conference. It was an online webinar. 30% of them said the CFO is the one who manages and makes the ultimate decision. And it surprised all of us. But it goes to show that depending on your company, depending on how important intellectual property is, anybody can be the manager. Any of the C-suite can be head of engineering, but in a holistic culture, you want to make sure everybody has input. And any of these stakeholders can manage the IP, but they certainly all deserve, and the company deserves, to have their input in making decisions. Any questions before I move to the next slide?
So there is a question in the chat. If an angel investor tells the startup after the pitch meeting that the provisionals are meaningless, should the startup dump this investor? What should be the next steps?
Well, I think I'd talk to a patent attorney to see, because you could tell. Well, I'd ask him why. I would ask them why he thinks they're worthless, to get some feedback. But I'm a big believer in listening, especially with investors, right? And I would definitely, regroup with your patent attorney and figure out what's the story here, right? Because the patent attorney, if you've worked with one, if you work closely with one who's thoughtful, they can help you understand, looking at your product, nobody knows it better than this small startup company that's raising money. And what is it that is different that's never been done before? What problems were you set out to solve? So often this is where I usually start, especially with people that don't have a background or haven't any experience being an author or an inventor of a patent. Talk about the problem that they were out to solve. And they talk about that. They remember the problem. They always remember the problem. The solution is usually something that's built up over time. Often 12 months ago, they had this insurmountable problem that they solved, but that happened 12 months ago. If you ask them what's new, they'll say something that they fixed last week, because that's just how they work. Engineering is not deductive reasoning, right? They always have to build up on something. So often what you'll find are the inventions have been stacked up and have built up along the path of building this thing, and understand what is new, what is the problem you solve, and that solution, how did you articulate the solution, problem and the solution, in the patent application, in the provisionals? And if this person is sincere, he really sees fault, or this investor really sees some flaws in there, then you should likely find them if they really are there. I think I saw some other questions come in.
Yes. Another question that we have is, we filed for a patent in India. We designed and developed in-house, but the same concept is there in Europe, but totally new in India. How do we stop even big companies from getting into the competition in the future?
Okay, this is a timing thing. So patents, United States and other countries, it's a first to file system. It didn't used to be that way, but it's a first to file system. So if you invent something in India and someone invents the same or a very similar thing in Europe, independently, we're not talking about theft of trade secrets, and someone filed a patent application in Europe, they win. You can't file after them and expect to get the same coverage. But it's not the end of the story. It rarely is the end of the story. Often the thing that you did, there is something different that you did that maybe this other application you're finding did not do. Every invention is built upon something, right? You're not just walking into a complete greenfield place where no one's ever done this thing before, right? I mean, God made the heavens and the earth, and man, cracked rocks together and made iPhones, right? There's something along the path that happened to actually make those things, but you're always building on something. So look at the thing, the solution, the problem you were addressing, the solution you came up with, and get down into the details. So often when I do a search and I come back after a person has explained to me their invention, I'll show them the art, or I'll discuss it with them anyway. I might not show it to them. And they'll say, okay, I know what that is, but that's not what we're doing. Ours is different. And that's what we cover in the patents application. But otherwise, if your invention is made somewhere else and filed somewhere else before you file, you lose. You can't file anywhere in the world, for that matter. In the United States, if this art, prior art they call it, something that happened before you filed your patent application, if it exists anywhere in the world before you file the patent application, you can't file yours. It's prior art. It's already been done. Any follow-up questions on that?
Yes. Another question. If I'm combining different equipment and combining it in a new way to build a system, do I have intellectual properly if I have not written any software code?
Well, sure. Again, everything is built upon something else, right? The question that you have to ask, these are different components that have been used before, right? In different ways to have different results. When you put them together, is that something that's not obvious? Because that's the next question, right? Is it new? Sure, it's new. It's never been done before, according to, as far as you know, right? Is it useful? That's usually the easy question to answer. Of course, it's useful, or you wouldn't be putting this thing together. Is it obvious? Is it a very straightforward thing that anyone who has your level of background, your educational background, your experience, would an expert in this area of technology look at this and say, of course, that's what anybody would do, right? I know it sounds very subjective. It is very subjective, but it's an argument you ultimately need to make to the examiner. And you want to try to figure out what that is. What is that differentiation? Is it not obvious? Why is it not obvious? And you have to be ready to articulate that if you're going to take the step and try to protect it with patents. Now, how do you do that? Well, talking to the examiner, they might see this as an obvious improvement, right? The argument that counters that is there are secondary considerations that were not taken into account, right? It changes the performance of this thing that was unforeseen outcomes. There may even be some literature that says this can't be done. It can't be done. In fact, we did run across it it was a video AI application I was working on, and they were looking to see whether or not this AI looking at people and looking at people's behavior that have been done before, right? The prior art had these very specific modules, components that did very limited things that could count people as they walk by, and they could differentiate a dog from a person, from a child, from an adult, right? The new invention was looking at a camera that was just like a security camera that was just looking down and was taking information that was that was not uniform. And the technology, the software, the algorithms that were required to take that information and make the same conclusions from this different technology, that's what was new. The prior art could not do that. So the answer is always, is this thing that you're doing something that's never been done before, and is it obvious in light of what you see in the prior art?
Great, thank you. And those are the questions for now.
Great. And again, every time you run into this, it's worth the discussion. You're not going to find, some case or some patent that's directly on point. It's always something that needs a discussion. What is the new? What is the thing that you're doing? Let's articulate this thing. Let's look at the prior art. Has this been done before, right? And you want to really look at it objectively and subjectively and test yourself and see, is this intellectual property? Is it really yours? Or is it something that really has been done before? Or ultimately it's not worth investing in because it's not, the thing is not differentiable. So the management strategy is you don't want to cut arbitrarily in times of strife. You want to audit for efficient patent prosecution, right? So this is kind of important. So a lot of people hire attorneys and they trust them, and they believe that, of course, attorneys always have their client's interest at stake, and they're always trying to be careful, right? But you want to make sure that you're really getting your money's worth what you're getting. And some people are efficient in any profession. Some people are not efficient in the same profession. So you want to really question your costs and what it really takes to get this patent through. So I'm going to switch down to something. This goes to cost. I'll get back to these slides later if we have time. So here is a process, and feel free to share this. And for the attorneys out there, feel free to reach out with any questions about this. Years ago, I worked for a very large company. They were my client, and they wanted to get patents issued faster. And anyone who has experience with patents knows it takes a long time to get them through. Often the first office action can take 3 to 4 years, even in software. That's in the United States. And in foreign countries, it takes time also, right? Filing to issuance could take 4 to 5 years, and sometimes more, in different technologies and pharmaceuticals and different things like that. Using an expedited approach that I've developed, you can get them done faster. And it's actually quite simple. Those years ago, I was filing lots of patents for this big company. I built their whole portfolio. They wanted to get them done faster. And you could pay, I think it's $4,800 or more now, to accelerate the patent, to put it in track. Well, there's track 1, there's track 2, and it gets you a little bit faster, but it's not that much faster. It's certainly not worth the money. You're better off taking that money and filing more patent applications. But all I did is I started calling up examiners, and I had hundreds of cases with this client. And ultimately, I just broke it down to a simple formula. I would talk to the examiner, ask them, this is like months after we file, not years, but months after we file, and walk them through the patent application. talk them through the claims, the drawing, explain to them what this invention really is, maybe even focus on specific features that you claimed. And then you explain with the claims, this is how I articulated these in the claims. Now we can talk about this, and you've got my search results. There's my claims. Do you have any questions? Right? A lot of trial and error there. I mean, I spent 150 to 160 hours per month just for this client because they were giving me lots of work. I didn't charge them for the time because I had no reason to believe that it could even work. But it started to work, especially with the younger patent examiners who needed help. They were still rusty and they were still learning, and I was helping them get this done. So you essentially do their job for them. You talk to them, you walk them through it, and they don't want to set the case down after you talk to them because it's fresh in their mind. They want to read it, examine it, it's really just a verifying search. I was getting office actions within weeks, so it's faster. But to the point I made earlier, you want to be efficient, inexpensive. It turns out overall, it's really inexpensive. It cuts down the time you spend in the patent office, fewer correspondence with the patent examiner. And you'll see when you hire attorneys, each one of these responses require time. It costs money. That's where the real expense is in patents, not just getting them on file. We cut them down by like 80%. And we ended up getting a much less expensive result from filing the application to getting the patent issued. Spent less time in the patent office, less attorney time, was much less expensive. In fact, the metrics we've figured out over time where it roughly takes $35,000 to $40,000 to get a patent application software, that's a busy application, from filing to issuance. And that's because most attorneys, they do it the old-fashioned way, send correspondence back and forth, they don't reach out to the examiner. Not enough attorneys do, and it just takes more time. The examiner responds just like you do. You throw it over the wall, they're gonna throw it back over the wall. If you talk to them and you really talk about, what is keeping this patent from getting allowed, you will get right to the point, and when you send in that office action, it'll be dead on point. At the very least, you should be able to overcome the search results, any kind of rejections that you got, send them back for more searching, but you move the patent closer to issuance. This is what saves you money. Now, how does that help you? You don't know what's happening in the lawyer's office. Well, talk to your lawyers, ask them. Every office action, there's an opportunity to talk to the examiner. Every time we have an opportunity to talk to the examiner, I pick up the phone and schedule a time, or I have my staff schedule a time. We talk to the examiner. Anytime you make contact with them, you could always, reach out and offer help to them. What do they really need to move this along? Often it's something you didn't expect. You can help them quite quickly, even have a brief discussion, and it moves it along. So we've had cases, these numbers are real that I'm showing on your screen. I've had patent applications that have come in, and I use this approach, even in the group 3600 group. Now, group 3600 is where business model patents go, things that touch transactions. Examiners don't like to allow these cases because they get bad press on these things. And I've gotten 2 cases recently that were allowed in that group within 8 months of filing. So I filed it, a couple months later, called the examiner. Within 6 months later, I had a patent issued from it. So this method really works. And I'm sharing it because it's an example of that not many even practitioners understand very well. You can connect with examiners and they want to talk to you. And they will help you help them. And if you can cut the time that it spends in the patent office, you're going to save money and just have a happier client. Right? And why spend more than you need to? Any questions there? I usually get some from the attorneys on that method.
During these times with tight budgets, what are some ways that we can creatively preserve patents and address office actions and maintain IP?
Got it. Good question. I was just going to get into that next. Well, so provisional applications are, that is for if you haven't filed any patent applications, provisional applications are relatively inexpensive. So we have a flat rate for filing a provisional application, and that's $640, and it includes the filing fee of $140 in case that's changed. And if you need any of our help, we'll work out what we need to get that information into the patent application to help you. But we'll always give you feedback. So, early startups, struggling startups, if you don't have any money, you have more time than money, you could spend time drafting these technical documents, and you can take advantage of that great deal and get your provisional patent application protected. You can also do that if you have a patent application that's pending a non-provisional application. You can file a provisional application that includes that, and later on, within 12 months, you can convert that to a non-provisional and combine it with the original application. So that's ways of getting new applications filed at low cost. It buys you 12 months, essentially, right? Really 10 months, because you have to engage with the patent attorney so you can make the filing, complete the application within 12 months of filing the provisional application. That's easy. It's a little more difficult when you got a patent application that is pending in the patent office, and you receive an office action and you need to respond. Okay, so different things you can do. Any way that you can help your attorney in overcoming the rejections should save you money by saving them time. So if you're really into saving costs, and I think you should do this anyway if you have time, and it's worth it, is to have the inventors take a look at the art that has been cited, or describe to them, in a brief one-pager, your claims have been rejected. Here's generally what this art shows, and here's how it shows it, right? The inventor can often find out, okay, ours is different, and here's why. And it's important to get that input. And if it's a small company, also from the business side, the CEO or anyone else involved, find out what is different that is still valuable. Because what you can do, you can amend the claims, you change the claims, and get the patent allowed. When you do that, you're often narrowing the claim, not covering as much because you made some change, you made it more specific. So if you're going to make it more specific, don't make it specific arbitrarily. Some component that doesn't matter, some function that doesn't matter. Focus on the thing that is important, that matters, and make as few amendments as you can. So when you give them that feedback, this office action response that an attorney needs to draft and pay fees and submit, you're going to save money and time there. Now, for a non-final rejection, there's two types: there's final and there's non-final. For a non-final rejection, an office action, you have 3 months to respond without any fees, without any extension fees or anything, right? So you can push that to the end. Of course, you want to work with your attorneys to make sure they have time that they can file it within 3 months, and buy that 3 months. Now, if it's a final rejection, you only have 2 months. And the reason is, on the final, if you submit a response within 2 months, they are required to give you a response back. If you don't respond to a final office action, rejection of your claims, within 2 months, they have no obligation to respond to you at all. You can file that response at 2.5 months if it's final, if it's a response to a final office action, and it could just disappear and you won't hear anything. So you don't want the thing to go abandoned. You don't want it to die in the patent office. So you want to make sure you respond in time. Now, if you have a non-final office action, you can take up to 6 months, but after the 3rd month, extension fees kick in. So every 30 days, there's another extension fee. You can take up to 3 months. You can actually take up to 4 months if you had a final office action. So you pay more, and it goes up. It gets higher and higher. Now, it's like credit card debt, right? I mean, after that 3rd month, you need to decide, can you really afford to respond to this thing? And will you have the money in 2 or 3 more months anyway? And you're going to have to pay the fee for the attorney to do it anyway. The extension fees add to that. But it might be, it is an opportunity to buy some time, and there's a clear price on what that time costs, to kick it down a month, 2 months, or 3 months. What else can you do? You could file a continuation with different claims. Now, if you don't respond to an outstanding office action, eventually that patent application will go abandoned for not responding to the office action. And that's the 6-month point. So if you file a continuation, that application has a brand new life. You can file similar claims. You're still going to get a response from the examiner, but you could kick it down the road further by just drafting a new set of claims. Of course, you can do them yourself, or you can have your patent attorney do it, but it only saves you the amount of money you would spend on the office action response. So you have to really know what you're doing if you're doing that, buying time, and it's unclear how much time you're really going to buy, because the examiner might respond quickly when you file this continuation. You can, for provisional applications, let's say you have to convert a provisional application, you have 12 months, right? Well, 10 months, you're running low on cash. You know, there's a disaster going on, you're trying to save money. If it's an important provisional application, you're going to need to convert it. But you really only need to convert it for, there's two things. One, if you made, used, or sold it, if you disclosed it in a white paper, if you talked about it at a conference, disclose the contents, disclose enough information that enables the invention. So if I heard what you disclose, or read what you disclose, or looked at what your product that you disclose, would I understand it? Could I make it myself without any experimentation? You've disclosed your information. So you're gonna, if you're gonna lose that filing date, you have to be aware of what you're really losing. So let's say you sold this thing at the 10-month point. You signed a sales contract, or you disclosed it somehow. If you lose that earlier filing date by kicking it down the road and refiling the provisional application, you have a new filing date. The old filing date will go away after 12 months. So if you have a sale in between, or before you file the second provisional application, you've lost your foreign rights, and you've started the trigger for the United States for disclosure. So if you have a sale, 2 months later, you file a provisional patent application, you don't have 12 months before you have to convert it. You have 10 months before you convert it, because you have a sale. You must do it before you do that. And these are the things that kick in when you start kicking these things down the road. Any other questions in this regard?
Yes. Are there firms that fund IP, especially IP-backed loans and such?
IP-backed loans. Well, in patent prosecution, filing for patents, you're not going to find many firms that will work for, say, stock, right? That will fund this thing, right? So any firm that is going to fund your efforts with intellectual property is going to expect some kind of return, whether it's stock in a company that's going to build a product and increase in value, or if they're filing patents for future litigation, licensing, patent lawsuits in the future, they're going to want something in return. And that could be a percentage of any of the returns on litigation. It could be specifically stock in exchange for the work that they're done, or something else. For litigation, that's completely different. If you have patents that are issued, patents that have not been issued, usually you have to have something issued, something enforceable. Then you work out an agreement with these attorneys that, if they will enforce them for a percentage of the return of the royalties or whatever damages that they get. That's worth a discussion all in and of itself. There's a lot to that. But if you're really strapped, whether it's your company or you have this intellectual property, it never hurts to talk to an attorney to look for a creative way to preserve your intellectual property, and maybe the possibility for future revenue or some kind of future payback for the work that they're doing. Any other questions there?
That's it.
Okay, great. How am I doing on time? So it's already
12:30, but we can go another 10 minutes. That shouldn't be a problem.
Oh, sure. Right. Okay. It's a good time to jump in with any questions, because there's a couple slides left. But since you're here with the extra time, I certainly want to pay you back by talking about what you want to talk about, right? So I'm in slide alignment of value and risk with the customer requirements. So this is one of the lenses that you use when you're trying to figure out what is valuable, which intellectual property is valuable. I mean, there's lots of bells and whistles, different things that inventors can come up with. You can invest in these filings, often they're valuable. But the most valuable ones are the ones that relate to your product and the indemnities and representations that you make when you sell them. Now, these are also reasons why you file patents at all, right? Often many software companies, we don't believe in patents, we don't do that. right? But they will make indemnity promises, and they will also make representations and warranties. They will offer to defend and indemnify you if anybody sues you for patent infringement, right? Well, how do you do that, right? How do you represent that you own the technology? Often it'll say that explicitly in the contract, we own our technology, or some way of expressing that, right? How do you back that up? You back that up with patents. You back that up with copyrights too. You back that up with trade secrets. You have these things that prove that this is yours and you created it. And what it does is it gives your customers, more contentment, more feeling of understanding that you've controlled the risk to some extent. You've actually built something from scratch. It's not something you just took off the shelf. You patented it. You've got original copyrights, and you've actually developed your own code. It's not just freeware or something. And this was what supports your representations and warranties. And if you ever are in a situation where you have to defend or indemnify one of your customers, you want to have the tools to do that. You want to have the patents. You want to have, the ability to fight back with something for, a patent holder or a competitor who is trying to, disrupt your supply chain. Now, we could go into this in another talk, and we're out of time now, but you can buy patents in the open market, and it's something you should always consider. So if you are really in dire straits and you can't afford to file patents, you can't afford to maintain your patents, it's one option is to buy patents later. Let things go abandoned if you have to, or be so as selective as you can. But in the end, you can always support your needs for intellectual property, for patents, by buying them in the open market. There's millions of patents out there. You can often find some that are relevant to your product. More importantly, that will read on your competitors or others who might want to slow you down with actions in intellectual property. You can even rent patents. You can rent patents. There's an organization that buys patents. They even have a list of them. They'll tell you what companies their claims read on. You rent them for a certain amount of time, maybe for $100,000 or so. You use the patents. You fight your fight. You do it. You settle the agreement. Whatever you're doing, whatever's left of the patents, you return them after the action. So these are different ways creative ways you can, if you really have to, to cut down on your intellectual property investment, there's other opportunities to gain back your intellectual property power and punch by buying or even just, filing new patents when the economy resumes. Any questions here?
I think that's it.
Yeah, controlling vendors. This is what I want to hit on, which I thought was really interesting, because recently I was working with a company that bought a product. In fact, I alluded to it earlier. This large company bought a software product from a vendor. Now they gave this vendor, it was a startup company. They started with nothing. They gave them the blueprint of this customer need, everything that they needed, all of the functions and operations. They knew what they needed. This company took it, built a product, and built a company around it, made millions off of it. The subscriptions going forward were millions of dollars per year. And what the company overlooked when they hired this vendor was that they owned all the intellectual property. That is, the vendor owned all of it. They filed for patents because they took the basic requirements, figured out the function, the operation, and filed patents on it. The vendor owned them. So the customer doesn't own the patents. So they got their product. They're very happy with it. Saved them lots of money and made their operations much more efficient. But that vendor took that product and repurposed it and sold it to their competitors. Now, they should have seen this coming, of course, right? But they didn't expect that. They didn't expect that happening. Now one of the competitors has the same competitive advantage that they have of the software, right? They came to me and they said, well, now we've got a bunch of improvements. Do we have to give them to this guy? They've got all the patents on that, right? Well, you can control these vendors, right? You can buy patents, you can rent patents, you can do whatever you need to do to protect yourself against any kind of action. So if you separate from this vendor and you build it yourself or have another vendor with a better term, you can protect yourself by building up your war chest. You could also build up your war chest and renegotiate with this vendor with these new improvements so that they don't sell them to your competitors, or at least they don't sell them for a couple of years. See, there are creative ways of doing things with patents that can drive your business. There's another client I had, I actually built their patent portfolio, and they hired a vendor to bring in robots to do certain things in their retail space. So the client did not want to file patents, right? That is, I'm sorry, the vendor did not want to file patents. The client did want to file patents. The customer who asked for these things to be built and delivered to them filed patents all around their space, operations, networks, systems. They had a bunch of engineers who invented everything, and they, laid it all out. This vendor, a bunch of academics who didn't want to file patents, didn't have any patents. And their customer ended up with all the patents. So it's opposite of the last example I gave you. So now the customer, they're not going to sue this vendor because they want this vendor to supply them, right? But now they have the freedom to hire competitive vendors because they own the intellectual property. So this vendor gets their portion. They can get other vendors to do it for cheaper, better, just different, multiple vendors. Every big company wants multiple vendors. On top of that, if this vendor or any of these vendors want to sell to one of their competitors, they can, require permission. When you own the patents as a customer, they have to have your permission before you can use that technology. Now, when this vendor wants to go over to their competitor and sell it, they can delay them or even stop them from doing it. Very powerful thing, very powerful thing. Any questions in this regard?
No questions so far.
Got it. So procurement strategy, how you file patents, whether you organically invent things, you have ideation sessions, you get all the smart people together in your company and you come up with ideas, you file patents to protect yourself. You can buy patents on the open market. You could, like I said, you can rent patents, and you can even borrow patents. There's just one of these assets that you can exchange for different reasons to protect yourself. And if you have your own intellectual property, you could be at the middle of those bargains. So the investment strategy, this is true whether you're cutting back, you're expanding, any investment that you're looking at for intellectual property, the ones that are focused on the products. Now before I go to the other ones, you do want to protect your product, but what does that mean? If somebody steals any kind of feature, any innovations in your products, you want to be able to have the power to stop them, or to require a revenue, a royalty for the use of your technology. If you have some technology that's really particular to your product that no one will ever use, you can file patents on that, but that's not the most valuable patent. It seems perverse, but for the patents that you have, you want people to infringe. And when you use these patents, the only way you could ever enforce them is if someone is infringing them. So you want to get patents that companies infringe. Now, this doesn't mean you get patents that are on your product that they infringe if they steal your product. You want those. You can buy patents on the open market. You can even file for other patents that are focused on your ecosystem, right? So you want to innovate, you want to enter new markets. If you're looking to, produce a new product line that's related or unrelated to your products, you want to file patents that are focused on that ecosystem. And that includes patents that other people are developing that they may infringe. If you see the next trend, if you're visionary enough to see this next trend and you come up with it, you can file patents. You can even file patents where if you imagined another competitor building this invention into their patents, implementing it into their products, you could get patents and claims specifically on their products. So for example, if you were working with a company and Oracle was a competitor and Google was another competitor, right? It doesn't take much extra effort. You already know what the invention is for the inventor or other people in the company to imagine and develop a description, a technical description that focuses on how would Oracle do this? How would Synopsys do this? How would Intel do this? Any other company, you can cover that because you've got the invention And you can get claims that cover the functions of your invention around your ecosystem in other companies' products. So it's a smart thing to do. It doesn't take that much time to sit down with your patent attorney and explain the use of your invention in other environments and with competitors. And of course, you can purchase patents. You can purchase patents for any use, any specific focus, and you can narrowly target them. And again, it's a buyer's market, so purchasing patents is quite feasible, and you could often get them for the cost of the prosecution that they already paid for to get permission. I think you saw a question come in. No?
Yes. One last question. How should a startup select an IP attorney, large firms versus small companies?
Good question. I've worked for large firms. I am a relatively small firm. Either way you go, hire the lawyer, don't hire the firm. Nobody looks at patents and to see who wrote the patent and say, oh, that must be a powerful patent. Look who wrote that, right? Big company, big firm. Often, like bigger companies, when you have a legal staff and they're hiring outside counsel, often what they'll do is they'll choose the big firm for no better reason than no one ever got fired for hiring this big firm, right? I hired the best, I hired the biggest, we paid a lot of money. I'm sorry we got a bad result and we lost, but that's what we did, right? My advice is build a relationship with your attorneys. More importantly, get referrals, right? Talk to your friends, talk to other companies. Often, even if you find a company that's maybe not your competitor, of course, but you talk to another company that's in your ecosystem, talk to them, ask them who they use, right? When you go to conferences, you see other CEOs, you see other engineers, you see other people who you can trust, you can talk to this about. You can ask them who they use. I get most of my work from referrals because when clients get referrals, they don't have to shop around so much, right? Takes less of your time, takes less of my time, right? I get lots of new clients I've never met or who don't know anybody I know. But you want to talk to the lawyer who's going to do what you need to do. Because in the end, it's one patent attorney who writes your patent. And that patent attorney will also deal with the patent examiner and will help you get the patent issued and will help you with the whole life cycle of the patent. It's not 100 attorneys, 200 attorneys at some firm. Even with litigation, you're not going to have more than 3 or 4 attorneys who are handling your case. You don't need to go to a firm with 1,200 attorneys, right? You can decide what's better or worse, but in the end, you want to go with someone that you trust and you want to educate yourself. Now, I talked about earlier, learn about your product before you buy it, right? If you're going to buy a house or buy a car, you're not just going to blindly trust those salespeople to give them to you, right? Because the person, when you go to a firm, they're selling you on their services, right? Do your own homework, right? Anybody can tell you about their own services and how good they are. Talk to other people, ask them for referrals. I've given referrals, talk to my clients, right? It's more important to talk to the attorney. Now, smaller firms can work with you more. They're much more flexible. We even do arrangements with startups where there's a combination of stock and cash, sometimes all stock, if that's what they want to do, and other types of arrangements. In this environment, I'm working with all of my clients to help them cut costs. We're getting creative, and I'm even cutting down my rates. So you can do that. Big firms don't always have the freedom to do that. Some of them do, but decide what's important to you, but shop around if you're not familiar with it. That's the best advice I can give you if you forget everything else we talked about today.
I think those are the questions for now. And we are at 12:45, so
right.
We'll wrap it up shortly.
Yeah, sure. Well, I can close here. If anybody has any questions, feel free to send me an email or give me a call. I'm a TiE charter member, and I'm dedicated to the organization. So if you're watching this at home and at your office, probably at home if you're not at your office, then reach out to me. Happy to have a call with you to discuss these issues. They can become very complicated, especially in times of strife. You don't want to have regret months from now when the world reopens and you saved a few dollars on your IP assets and you had to give up something valuable. So you've got my contact information, and I'm also going to I have backup slides. I'll make those all available to anybody who attended. This is my contact information on the screen right now. Feel free to reach out, and good luck. Keep those companies alive.
Thank you so much for your time, Dave. And thank you everyone else for joining as well.
Thank you. Thanks for all your support. This is great.